In this video, we're covering the 12 tips to defending your next deposition. Because you know how the old sports saying goes, defense wins depositions. Welcome to Law Venture, a channel devoted to lawyers and future lawyers. My name is Jarrett Stone. I'm the owner of Stone Firm P LLC, and today we're talking about defense. We're talking about defending your next deposition. What does this concept of defending a deposition actually mean? Well, for the purpose of this video, we're going to take it in the traditional sense, meaning that your client is the one who is the deponent, the one who is being questioned during the deposition, and is typically going to be primarily questioned or examined by the other party's lawyer. This all means that with this lesson, with this particular video, we're going to cover 12 tips so you can protect your client at the deposition and then ultimately protect your client's overall case. But before we dive into the 12 tips, very briefly, we need to cover some housekeeping matters, get everyone oriented. First things first, if you're on YouTube, then consider hitting that like button. It helps not only the video, but it helps the channel overall. It really makes a difference. And also consider subscribing if you haven't already. That way you can see future content as it's released and you can stay up to date on the latest tips and tricks when it comes to taking your legal career to the next level. Finally, if you are on YouTube, then consider going over to lawventure.com right now. Hit the courses tab. It'll take you to the deposition course that involves this particular video, because this video is a mere lesson in an entire free online course involving depositions. So if you're looking to take your depositions to the next level, lawventure.com, that's where you need to go. Go check it out. I'll have a link that slides above. So let's get started with tip number 1. Silence is golden. With tip number 1, you really want to prepare your clients for the deposition well in advance of the deposition. Even if it's 24 hours in advance, that's fine. Just be sure to go through anything and everything to make it an effective preparation, because preparation is key, not only when it comes to trial, but in this particular situation, when it comes to your client's deposition. Now, I'm not one to minimize or couch a Law Venture video and the importance of the content in that video, but I'm gonna be honest here. If you spend a lot of time and really have a very thorough preparation for your clients for their upcoming deposition, then the upcoming tips that we're about to go through, tips 2 through 12, aren't nearly as important. That's why silence is golden. And what I mean by this is that if your client is prepared for all the ins and outs of the depositions, if your client knows the hot topics that the other side is going to be asking questions on, and not only knows them, but knows how to answer them, and if your client knows what not to say or what to say in certain situations, all you need to do as the lawyer is just sit back and watch the show. So how do you effectively prepare your clients for their upcoming deposition? Well, in order to help spark some ideas, I do have the 12 do's and don'ts that I always give to my clients in advance of their deposition. I recommend checking that out, maybe even sending it to your client or taking nuggets from it to implement whenever you do talk to your client during that preparation stage. That is super helpful. That's something that, in fact, I've had a client check out that video before I even sent it to them. And then I ended up talking to the client. They're like, hey, I saw you on YouTube with this whole Law Venture thing. So again, check it out. Super helpful. It's still not sliding. At this point, it's probably slid back. So you may need to rewind a little bit. But start with that, and then also go through in your mind the hot topics that you know the other side wants to talk about. Help formulate the responses with your client. You're not giving them a script to where it's like a scene out of The Office and they say something like this.
Line.
I'm sorry, what?
He asked for a line, like in a play.
But it can be really effective if you help your client in advance formulate their thoughts into words. Sometimes the client, they know how they feel about something. Sometimes they know exactly what they want the message to be. They know the intention behind their words, but they don't know how to clearly convey it. That's when your job as a lawyer comes in, especially during the preparation stage in advance of the deposition, to where you kind of get the testimony in advance, your client's speaking to you, and then maybe you say, well, maybe we take this approach, or maybe we convey it like this. And then that way your client has a little bit more confidence on what they say. Tip number 2 is know the purpose of discovery. So here's an important message that I think less experienced attorneys need to understand, and something that you really need to convey to your clients during that preparation stage as well, which is that in discovery, especially with depositions, just because certain evidence or certain testimony comes out during discovery or the deposition doesn't mean that it's actually going to be presented to the jury. This is an important distinction that needs to be made. When we really simplify the purpose of discovery and depositions, the other side is allowed to ask for evidence or testimony that appears reasonably calculated to lead to discovery of admissible evidence. Look, this is an important concept to understand because some attorneys, they start getting extremely defensive and they overreact, and it could, at the end of the day, affect the ultimate resolution, and if it's a personal injury case, what your client could potentially be pocketing. That's a lot of abstract thoughts there, so let's make this more concrete by way of example. During your client's deposition, it's most likely a matter of when, not if, the deposition gets uncomfortable for either your client or yourself as the attorney. What do I mean by this? At some point, most likely, the other side's attorney is going to ask questions that weaken your client's case on paper. But if they're asking questions that you know will be inadmissible at trial, or the testimony will be inadmissible at trial, then they can talk about all those weak points of the case, but that will never be presented to the actual jury. What does that mean? That means most likely you're gonna need a motion in limine. I have a video sliding above if you need to get familiar with motions in limine, and then you're gonna limine all that inadmissible evidence out, or you're gonna raise timely objections in order to keep it out so that it's never heard in front of the jury. You need to have confidence in your knowledge when it comes to the rules of evidence, knowing, yeah, y'all can talk about this all day, but this isn't coming in at trial. And then that's ultimately, that confidence and knowledge is going to ultimately help you when it's time to settle, assuming you're a plaintiff attorney like myself in a personal injury case. Because let's say you go to mediation, the other side says, well, we have this fact, this fact, this fact, and this fact. That's why we're offering this low amount of an offer. And then you hear all those facts and it's like, well, that's all speculative. None of that's coming in at trial. So I'm not even gonna consider that in the actual settlement offer that I'm sending you. Mediator hopefully is experienced and is agreeing with you in that situation. And that allows you to start pulling those offers up because, again, you're hopefully mastering your rules of evidence, ultimately reverse engineering how trial is going to go and bringing it back to the offer. And so that all begins during the deposition stage. That all begins whenever you hear that evidence that is going to be inadmissible being presented either via the question or the testimony. Make your objection if you need to make it, but no need to put your foot down. Let them go through their questions because, as the rule states, those inadmissible questions or inadmissible testimony may reasonably be calculated to leading towards admissible testimony. So you gotta just take the body blows, let it happen, and then keep defending your client's deposition. So I had to grab my tea real quick because I just ranted and gave you a preaching session and realized I grabbed the wife's mug today and it says, "Hello, beautiful." That's so sweet. Hello. Tip number 3, know the rules of objections. This one right here is a little bit of a cop-out on my end. I always stress you need to know your rules in your jurisdiction. I don't want you to assume in this video, in this particular lesson, that everything I'm saying here is gospel. Figure out what is allowed. In particular, with objections, are you only allowed to say objection form, meaning you're just basically saying form, 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 form. That's how Texas is. Or are you allowed to have more speaking objections? Speaking objections, though, that is a spectrum. You ask one lawyer what a speaking objection is, and you ask another lawyer, you're gonna get 2 different definitions. On one end of the speaking objection spectrum, which is a mouthful to say, and I've never said that phrase before in my life, you could have something as simple as objection, speculation, something like that. But on the other end, a speaking objection could also be objection, this question calls for my client to speculate because my client doesn't have personal knowledge on the matters being asked about. That's a long-winded speaking objection. And the latter, this end of the speaking objection spectrum, which is a mouthful to say, seriously. That's something that courts frown upon. That's why in Texas, the default is objection form, because the fear is with this long-winded speaking objection and with no judge around to really police it, the client, after they hear that rant of an objection, would be like, oh yeah, okay, this is speculation. Yes, so I don't actually have personal knowledge on that. I would be speculating, so unfortunately I can't answer that. Sneezed off camera real quick, that's why my eyes are watering. So with the speaking objections, you need to know what's allowed, what's not allowed. In Texas, like I said, we're kind of limited to objection form, but there's a little bit of gray area, I'll say. There's a little bit of massaging in order to use a little bit more of an objection or a longer form of an objection that may help your client, may not, or may help the record, may not. We'll talk about that in the upcoming tips. Let's move on to tip number 4. With tip number 4, use objection form to your advantage. Now you may be thinking, if you're not familiar with objection form, Jarrett, what in the world is that? I watched your top 10 video that is maybe sliding above. I don't know if I hit my limit on what can slide above. If I did hit my limit, I'll link down below. An objection form was not in your top 10 video. In fact, I downloaded the free objection cheat sheet, which may be sliding above, may not be. An objection form wasn't in the free objection cheat sheet, which looks like that bad boy. There are 21 objections, and form isn't one of them. Well, in reality, form is basically insert here, and it's totally different than being in trial. In trial, if a question calls for hearsay, you would object, Your Honor, calls for hearsay. Your Honor, hearsay. Objection, hearsay. And you're just like rattling it off, having to come up with the objection in the moment, conveying it to the judge so the judge can rule in that moment as well, or allow opposing counsel to argue on why it's not hearsay. You gotta be quick on your feet at trial. Deposition, a little bit more laid back. All you have to do is say form, and in doing so, you don't really have to come up with your particular objection. Now, make sure it's in good faith. We'll talk about why that needs to be the case in a second. But what you end up doing in that situation is you just say form, and if you need to come back and maybe object down the road or flush out why you made that objection, look at the transcript, look at the form objection, preserved your objection with form, and then you just do the insert here. Your Honor, we objected to this because this calls for hearsay. It's a whole lot easier to object to form, and it's fantastic. But it, again, needs to be done in good faith, because if opposing counsel asks you for the basis of the objection, then you need to come up with a good basis. So use your judgment there whenever you make the form objections. Don't use it as a crutch. Use it in good faith and use it strategically. So let's talk about that. You don't want to overdo it and just rapid fire with these form objections, because the risk you run, and you always need to be conscious of this, is you don't want in the back of the client's mind to have them freak out to where they're like, man, my attorney's being really active right now, objecting left and right. Is it based on what I'm saying? Is it based on this lawyer doing something improper? It doesn't sound improper. And then their mind is kind of spending a little bit too much energy focused on what you're doing and not enough energy focusing on what they're saying and what they're testifying, and maybe thinking in advance of where these questions are going. So kind of simplify the overall process by, again, in good faith, using the form objection when necessary. Tip number 5, consider using speaking objections. I'm pretty proud to say that when I prepare my clients, I typically don't need to have a speaking objection. I tell them how to prepare for potential issues like speculation, legal conclusions, how to respond to that. And most clients, if they made it this far in the litigation process, are comfortable with having a deposition taken. The ones that are like, no, like I'm not gonna do well with the deposition, those are the ones who are like, yeah, let's get this one settled. I'll take a lesser amount because I don't wanna have to do that. So that kind of weeds out to where the clients that are willing to have a deposition are a little bit, they're just better witnesses and a little bit more comfortable on the stand, so to speak. And in doing so, I can just typically sit back, make my form objection, and move on. But every now and then, and it could be because of bad questions from the opposing counsel, or the client could get a little rattled or a little flustered or just kind of wearing down after, a series of questions or maybe a long day, I'll throw in that quick little mini speaking objection that lets the client know hey, like, here's what's going on, and allows the client to get centered. For example, let's keep using speculation in these examples. I'll prepare my client in advance of the deposition, if we go back to tip number 1, about speculation. And part of that preparation is letting the client know, hey, if you hear me object to speculation, then you know that this is involving speculation. Now, if I'm wrong in my objection, if you do have personal knowledge about it, testify away. Testify what you have personal knowledge on. But if you get frazzled or something and I feel like you're guessing or you're saying, well, I don't know, maybe it's this, maybe it's that, and you hear me say form, speculation, then that's a pretty good indicator that there may be speculation going on. And if that's the case, come back to your home base, come back to, okay, I can't answer this because I'd be speculating or I have personal knowledge on it. And that way the client has that kind of like, hey, over here, here's a quick reminder in the moment, and allows things to go a little bit more smoothly moving forward. So that's one little trick that I like to use, and I use it very sparingly, but it can sometimes help things be a little bit smoother for the client if I do throw in that one life support here and there. And in my mind, it's a lot like objecting speculation at trial. The witness or my client in that situation who'd be on the stand, let's say being cross-examined, if I stood up, I said, objection, Your Honor, calls for speculation, the client knows what that means, so the client's gonna be prepared. So me saying form, speculation isn't too far off from that general principle. Tip number 6, clarify the record. So I've become a little bit of a record snob, if I'm being totally honest. And I think it's because a lot of my class action work is very record intensive, and there's all these technicalities that the other side's trying to get you thrown out on. And so I try and make sure everything is bulletproof and as on the record and pointed as possible. And what I've noticed during depositions, especially in the personal injury world where it's a little bit more relaxed on making sure the record isn't super kosher, is that sometimes what'll end up happening is the other side's lawyer will refer and ask questions involving a particular exhibit. Let's say it's a book of sorts. And in doing so, they'll have a question that says, okay, and in this exhibit, it says that. And the client who is looking at a particular page, at a particular sentence within a particular paragraph says, yes, it does say that. Well, in my situation, I'm ultra paranoid. I don't know what the other portions in the book or on the other pages say. What I don't want to happen is for us to go to trial and that statement of ambiguity be used to start pinpointing certain aspects of the book that my client really isn't talking about. So in moments like that, I'll specifically chime in and say, opposing counsel, whatever their name is, Mr. So-and-so, Mrs. So-and-so, just to be clear, whenever you say that, you're referring to page 7, paragraph 6, sentence number 2, yada, yada, yada. Sometimes that rubs the opposing counsel the wrong way because it seems like I'm being a stickler. And it's because I am. I need to protect my client, defend the deposition, and the best way I can do that is to pin down specifically what you're talking about so it doesn't get taken out of context. This whole book and paragraph situation can apply to pictures, photos, areas in a photo. So you wanna make sure, in order to protect your client, that everyone on the same page, on the written record, is talking about the same thing so that it doesn't get taken out of context down the road. Tip number 7, clarify the question. Look, when I take my depositions, I tell the witness, it's not a matter of if, it's a matter of when I ask a bad question. And if I ask a question you don't understand, please feel free to let me know you don't understand. I can ask it again, or I can rephrase it. You just let me know. I always get the okay. Typically, other opposing counsels, other lawyers on the other side say something very similar. My client says okay. But in the actual practice of the deposition, that sometimes doesn't always happen. And there are typically 2 scenarios that I see where I need to chime in and ask a question to help clarify what exactly is being asked by the other lawyer. Situation number 1 is when the lawyer is using terminology that in the legal context means one thing, but in the layperson context and from my client's perspective means another. Then what I'll do is immediately kind of chime in and ask, okay, are you asking in this context? Are you asking in that context? That way my client, who when they hear it in one form of fashion, understand it, they know exactly what is being asked and what they're gonna have to say in response to that. The other scenario is the client is just, feels like they're in a rhythm, but the attorney asks a question that just wasn't asked very well. And that sentence wasn't said very well. But I'm going to push through it anyways. And in doing so, my client, bless their heart, is trying to basically throw a bone to the defense lawyer in this situation by trying to assume, okay, based on the context of the words and the syntax being used, I think you're asking this, so I'm going to answer this way. But sometimes, just because it's a bad question, that interpretation is incorrect. And as a result, the answer ends up kind of being harmful in a way that wasn't intended. So I'll sometimes chime in if I see that happening or popping up, kind of consistently throughout the deposition to make sure, okay, are you asking this or are you asking that? And part of the rationale is so my client is on the same page and my client understands, and so I can protect my client. But the other part of it is, I don't know if I should object or what my objection should be if I don't even understand what's being asked or what information or testimony is being presented. And so that helps me make sure the record's clear as well. I'm hoping that made sense to you in the abstract, but just in case if it didn't, I'll give you a concrete example. In one of my class action depositions, my client, the plaintiff who is seeking to become a class representative on behalf of a whole bunch of people, because it's a class action, was having his deposition taken. Now, the defense lawyer, either intentionally or unintentionally, was going down a series of questions asking about how the plaintiff, my client, got in contact with myself. And they were all lawyer-driven questions. Okay, has your lawyer done this? Has your lawyer done that? Yada, yada, yada. And then she kind of pivoted, and I understood the context of it, but my client didn't, by saying, now, are you seeking to represent anyone in this case? In the context from my client's perspective, she's talking about lawyer, 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 and he hears representing, and so he understood it to mean, oh, yeah, I'm not an attorney, so I'm not seeking to represent anyone. In the context of the defense lawyer's case, she's asking questions about him being a class representative. And if he doesn't want to be a class representative, then there's no class action that's going to be viable in this situation. Kind of kills the case. So an important distinction that needs to be made in that situation, you need to step in and say, hey, just so I'm clear, Miss Defense Lawyer, when you say whether or not he's seeking to represent anyone, are you saying as a lawyer or as a class representative in this class action? That person, that defense lawyer, will hopefully just say, oh yeah, as a lawyer. And then my client says, no, I'm not a lawyer. Or no, as a class representative in this class action. Oh, well, obviously, yes, I wouldn't be here otherwise. That's a distinction that's important. So you need to be on your toes as the lawyer defending the client in the deposition. Tip number 8, protect privilege. I'm very quick to hop into a deposition to shut down any type of privileged communication so that my client, if he starts talking about privileged communications, doesn't accidentally waive those privileged communications. And you and I know, as lawyers, we ask questions that in our minds, we're not intending to try and elicit this kind of information. If we ask something like, okay, tell me who all you spoke with about the wreck. We're not asking about your attorney. We're asking about witnesses so we can eventually take the witness's deposition. But from the client's perspective, they just naturally are like, okay, who did I talk to most recently about it? Oh, talked to my lawyer right before this deposition. Okay, let me start talking about that. That's why I come in, I immediately shut it down. I ask the client and instruct the client not to elicit any type of privileged communication and to answer any questions beyond that privileged communication or to identify anyone beyond the privileged communication. And I try and also hammer this home during the preparation stage, circling back to tip number 1, but I don't play games with this one. I immediately chime in and immediately make it known, not talking about this, and that's usually respected by the other sides, where the other side maybe has a scope, like beyond any types of conversation that you had with your attorney in this case. Who all have you spoken with involving this car wreck? Tip number 9, take breaks. Breaks are super powerful because they allow the client to maybe get up, walk around, stretch their legs, get a little bit of a refreshment, and try and come back a little bit more energized to the deposition. I also like to use this time to help give confidence to the client to where I tell them how great they're doing. I liked this answer, and this answer to really kind of bolster them up a little bit and build that confidence. I also like to use the break in order to ask the client, hey, have you understood all the questions? Was there something that you didn't understand? And then in doing so, if I find that the client actually misunderstood a question or didn't clarify something to where, the question is going to be taken out of context or the answer is going to be taken out of context, I'll say, okay, once we go back on the record and the deposition kicks back up, you may want to bring that to light to the opposing counsel, say that you want to provide some type of clarity on this. In doing so, that will give you the opportunity to really flesh it out. And it also gives the opposing counsel the opportunity to ask additional questions to either figure out what all happened with the miscommunication or what exactly needs to be asked after that's fleshed out, and maybe another thought tree kind of goes with the deposition there. The point being, what you wouldn't want to happen is if the client misunderstood it and then potentially you're at trial and the client says something else and then the client ends up being impeached on cross-examination by the other side, and the client's defense is, no, I actually meant X, Y, and Z, which is different than what I actually said. Well, the cross-examination lawyer, let's assume the lawyer actually is skilled, is going to be like, but you had the opportunity to correct it. In fact, in the beginning, I said if you didn't understand it, you would let me know, and you never let me know. And that's not going to look good for your client. So it's better to address that after the break. So again, use that time wisely during your break. That's still not the number one reason I like to use breaks. I love taking breaks in order to remind the client to keep their answer short, sweet, and concise. Sometimes clients who are doing really, really well, they get some confidence. And in doing so, their answers get longer and longer. And so I'll go on a quick break and tell the client, look, you're doing fantastic, but we're going to be here as long as you want to be here at this point. You are in control, you are in the driver's seat. And so by going in more in detail than you need to go, you're gonna drag this out, and that's just going to be potentially more harmful for your case. It's gonna be a whole lot longer for everyone else. So again, short, sweet, and concise. Tip number 10, question your client only if necessary. For all the newbies out there, here's what's gonna happen in the deposition. The opposing counsel, they're gonna ask their questions, but once they're done, they're gonna pass the witness to you. You have one of two options. Option one, if your client killed it like they should have, then you just reserve your right to ask questions at trial. You're done. Your client's done, everyone goes home. Option two is you ask additional questions, you have your own examination, and then you pass the witness back to the original, or let's just say opposing counsel. And in that situation, with this tip, I put if necessary for a reason. You only want to do this in order to either do damage control or to maybe solidify something that may have been confusing. For example, let's go back to the client saying he didn't want to be a representative. Or let's just assume he said he didn't want to be a representative. If you understood that to be in the context of a lawyer, he's not seeking to be a class representative, and you know that your client didn't mean that, then you may want to ask a question or two to help clarify. You're talking about the context of you're not a lawyer. You have questions that flush that out without leading the witness and having proper questions. Then you've done your damage control. You get in, you get out, you pass the witness. They may ask additional questions. They kick it back to you. You reserve your right. Everyone goes home. Now, the risk you potentially run if you are trying to have this full-blown examination to get all this great information out of your client to get that on the record is that you're now putting the other side on notice of how your examination may go at trial, and that will better prepare them for their cross-examination. So again, you want to be short and sweet if necessary with your examination of your own client. If your client just did poorly and it's really hard to salvage your client's testimony, then you may honestly just want to bite the bullet. That's going to be a cost-benefit analysis that you're going to have to determine in the moment. Because if you start trying to do damage control and spotlighting all of these issues, then the other side, they're going to see you spotlighting these issues, and they know where the pressure points are moving forward in the case. And that may not be something that you want to tip your hand with. Again, make a judgment call there on what you're going to do. But the best way to defend your client, if there is that confusion and ambiguity on their answers or what's being asked, is to maybe have a few questions to help clear it up, and that'll better defend your client at the deposition. Tip number 11, project confidence. This one's simple and probably is obvious, but you can really build your client's confidence during the deposition and throughout the deposition with your body language, with your facial expressions, with how you're acting. For example, if you're laid back and just kind of watching the deposition unfold and your client knows you're paying attention, then your client's getting that silent affirmation that you don't really need to step in, that you're doing great. And I tell my clients during the preparation stage, like, look, if I'm not really saying anything, don't think I'm not paying attention. I'm definitely paying attention. And if I need to step in, I will. But if you're killing this, then I don't want to have to step on your toes because you're doing a great job. And so that type of confidence allows your client to get settled in, because depositions, they can be nerve-wracking for clients and for deponents. And if you can bring that confidence, that can be the X factor to help take that deposition to the next level for your client. Tip number 12, let your client review and sign the deposition. This one's pretty simple. At the beginning or end of the deposition, the stenographer at some point is going to ask your client whether or not they would like the opportunity to read, review, and sign off or make any corrections to the actual transcript itself. Sometimes stenographers, they'll mess up. They'll put so-and-so said this when another person said that, or they'll misspell something or put the wrong words in, or I don't know, I'm sure something worse has happened at some point down the road. But giving your client the opportunity to maybe fix those errors is a potential way of defending the deposition, because they can fix errors that may be harmful to them. In my situation, I haven't really seen any type of harmful errors with the stenographers that I've used. So 12 is kind of like a bonus. You got it if you need it. It's just something to consider. That sums up this video, the 12 tips to defending your client's deposition. If you have any questions, comments, concerns, thoughts, or you just want to say hi, leave those in the comment section down below. If you're on YouTube, then you're a rule breaker. I appreciate you. Don't forget to hit the like button. Don't forget to subscribe, and I'll see you in the next lesson.